So, good afternoon, everybody. My name is Derrick Hogan. I'm a partner here at Tully Rinckey. I've been practicing for about 15, 16 years now. Today, we're going to talk about the formal EEO complaint process and thereafter. I specialize in both federal and labor employment as well as criminal matters. I've handled matters before the EEOC, the MSPB, and the EEOC's Office of Federal Operations, which is the appellate branch of the EEOC. So looking forward to presenting today, advising everybody on the process, what steps to be taken, maybe provide some guidance, and we'll answer some questions at the end. Okay, what are we going to learn today? A couple things. When and how to file your formal EEO complaint, the timelines to understand during the formal EEO complaint process, the investigation of your formal EEO complaint, and then once the investigation's over, you'll receive what's known as a report of investigation, and then choices you have upon receipt of the report of investigation. So a couple things there. With the formal EEO complaint, that is, let's call it the second step in the process. You have to initiate EEO contact before you can file a formal EEO complaint. And the informal phase can last anywhere from 30 to 90 days, depending on if you grant an extension. But that is a misconception sometimes. People assume, or they say, well, I want to go right to formal, and you can't necessarily go right to formal. You have to go through the informal phase. Timelines. Timelines are very important. And that these are, they're important in the sense that these are strict deadlines, and if you miss these deadlines, you might not be able to move forward with your complaint, whether it's in the formal phase or if you go all the way to request an EEOC hearing. So it's very important that you understand the timelines because your claims or your complaints could be null and void in a sense if you do not meet those deadlines. Secondly, the investigation of your formal EEO complaint, we will talk about that. And then once your complaint is investigated, you will receive what is known as a report of investigation. And that is essentially a compilation of your complaint, any supporting documentation, an affidavit regarding your claims and your reasoning behind your claims. There'll be management testimony. So if you make certain allegations against a certain individual, that agency official has to provide an affidavit. And then you'll also have the opportunity to rebut the responsible management official's affidavit. So those are the types of things that we'll talk about today. We'll get in more depth as we move along. Okay, transition from the informal to the formal stage. So kind of like I said earlier, the big thing is you need to initiate an EEO complaint within 45 days of the discriminatory event. So in a sense, if something happened today, March 19th, you would have to initiate EEO contact within 45 days from today. And that's very important. So, for example, if something happened on March 19, 2024, you can file a complaint, but it'll be very unlikely to be accepted because ultimately it'll be dismissed as timely. So anytime you file something, as long as you file within 45 days of that event, you should be safe. Further, if you file a complaint and then you want to amend your complaint, you also want to make sure to amend it within 45 days of the event. If you file something today and then say on April 1st, a new event happens, you want to make sure you would file within 45 days of April 1, which would say, call it, May 15th. So that's very important because you might get through the informal stage with an untimely claim, if you will. But if you do go forward to the formal stage, ultimately that will be dismissed as untimely. And so at the end of that informal phase, if you're unable to reach an agreement, you will be issued what's known as a notice of right to file a formal complaint. And that is a letter from the agency which essentially states the informal phase is over. You now have the right to file a formal complaint. And this is very important because you have 15 days from receipt of that document to file your formal complaint. So today, think about it today. You received your notice of right to file formal complaint on today, March 19th, you will have until April 3rd, 2025 to file that formal complaint. The correspondence from the agency will usually have a form that you need to fill out, with your name, information, summary of the claims, and also you will want to describe your claims in depth so the agency has an idea of the events you're alleging, the allegations that you're setting forth. Once again, very important. You're going to hear me say this throughout the webinar is timeliness is important, because if you receive a formal complaint, a notice of right today on the 19th, and then, the April date comes, I think I said April 3rd, you try to file something on April 4th, it's ultimately going to be rejected as timely. So once you do receive that notice of right to file, basically you want to consider retaining counsel if you don't already have it, because that is a quick turnaround. Okay, filing a formal complaint. It must be filed within 15 days of receiving the written notice of right to file a formal from an EEO counselor. We just kind of went over that. A lot of times, just be careful. You might get a letter dated March 17th, but it wasn't emailed to you or mailed to you, and you did not receive it until the 19th. So it's always from the date of receipt. And also, if you have counsel, the deadline files prior to filing anything. If you have counsel already, that 15 days is going to start once your representation receives it. So very important to keep emails. Maybe it was emailed to you, and like I said, the letter's dated the 17th of March, but you receive it on the 19th. Keep your emails. Make sure you have timestamps so there's no question that you're filing it within time, within the requisite time. Unless you're amending the complaint to include newer events, you only want to include claims that you had included in the informal complaint. So in a sense, if you, in your informal complaint, alleged events A, B, C, D, and then in your filing your formal, you allege event E, but that happened before any of those things, or it's not a new occurrence, you're not going to want to include that, because that claim will ultimately be rejected. Not all your claims, but that particular claim. So do not include issues that you did not include in your informal complaint, unless, this is a big unless, those issues arose after the filing of your informal complaint. Same thing with the informal complaint. You must include what happened and why it happened. Okay, you're going to allege a certain event. I was discriminated, or, well, the big thing is the event first. What happened? Did you receive a personnel action? Has your supervisor been harassing you? Did you get a lower performance appraisal? Any of those types of issues that affect a condition term of employment, that's something that, and you allege that it's based on your race, your religion, your sex, your disability, any of those things. You want to include what happened and why it happened. And then once you do file that, you'll get two sets of correspondence from the agency. One is going to be an acknowledgement letter that basically says, we received your complaint filed on March 19th. We will then send a follow-up letter whether we accept or dismiss all or part of your claim. And that second letter, you will find out. The agency is going to say, we accepted all these claims. They might dismiss some because they're not an actual claim, an articulable claim. It doesn't affect the term privilege of employment, a condition of employment, or they might dismiss it for it being untimely. Kind of use the example I said. You allege something happened on March 19, 2024, well outside the time frame in which to file, and they will dismiss that. Okay, so what happens? You file your formal complaint, and the big thing is the agency has 180 days to investigate your complaint from the date of filing. Now, this 180 days, sometimes an investigator reaches out to you within a week or two of you filing your complaint. Sometimes, and I just had a case where we filed, I want to say back over the summer sometime, and we are just now receiving contact from an investigator. And that is well past the 180 days, and you do have options in connection with that. But I think it's very important for people to understand that, as soon as you file a formal complaint, it's not like you're going to be contacted right away. You may, but it might be months. And it's important for people to understand that. And I think it's important for attorneys to explain that to their client, because they think they may get contacted right away and they may not. And it could be for a variety of reasons. The agency's backlogged, the agency doesn't have enough personnel, things of that nature. But understand that is something that's out of your control. Once you file the formal complaint, you've done everything you've needed to do, and now you just wait to hear from an investigator. So what does the investigator do? I think a big thing you have to understand from the beginning of this is that in the formal complaint phase, and this is where a lot of people maybe get confused, is you will not get some type of decision from someone that says that you were discriminated against. It's going to say, you know, you're not going to get a decision by an investigator to say whether or not you were discriminated. The investigator's job is to compile all this information, to interview you, to interview the agency management officials. But in the end, you're going to get this report, the report of investigation. But it's imperative that people understand that they do not, the investigators don't make any decisions. And I think, you know, also as attorneys, it's important to advise their clients, because that's a big misconception. Client files a formal complaint, they think they're going to get a decision right away. That's not the case. But what will the investigator do? The investigator will reach out to you, and if any witnesses you identify, and they'll ask you to submit an affidavit regarding your claims. Now, usually they can do one of two ways. Most of the time, the investigator will draft an affidavit with questions already in it, and then they'll ask you as the complainant to fill out your responses to those questions. Specifically, they'll ask you about the claims at issue, why you think you were discriminated against, and maybe ask you some background information. The other way they'll do it is they will maybe interview you telephonically, in a sense where you give them answers and they transcribe it, they write it down. If they do it that way, I would prefer a written affidavit so there's no confusion as to what you're claiming and your reasons why. But if they do interview you telephonically, what they should do is provide you, whether it's a transcript or basically write-up of what you said, and give you the opportunity to review it and revise it as necessary. You might not get an actual, there's not going to be a stenographer, if you will, a court stenographer on the call, but if you do it telephonically, you should receive something after. And at that point, once you review your answers, they should allow you to make edits, and then you can go from there with it. And then once you submit your affidavit, they will also reach out to the responsible management officials. So, you know, in your claims, you know, individuals need to state, you know, I was discriminated against by this individual, or my supervisor did this to me. You know, a lot of times it's management above you, right? It's your first line, it's your second line supervisor that are doing the discriminatory actions. So if that management official is advised that, you know, employee X has filed a discrimination complaint and alleged that that management official did something, then the agency, then the investigator is going to reach out to the agency employee, and they're going to, once again, send that individual an affidavit and have questions based on the claims that you have made. And then once the management official provides their response, the investigator then reaches back out to you to give you a rebuttal opportunity. And essentially the rebuttal opportunity is something that allows you to, just like I said, rebut anything the management official said. You know, if the management official said ABC happened and you disagree with that, then you have an opportunity to then rebut what the management official said. It's important to note, though, when you do the rebuttal affidavits, that you're not just regurgitating all the arguments you made. I think sometimes people fall into that trap of they just want to reiterate all the arguments they made or the claims they made. That's not the case. I think if you need, for the rebuttal aspect, you should narrow it down, and you should tailor your responses to specifically rebutting what the management official said. And to go back a second, you know, with your own affidavit, it's time consuming. I feel, sometimes it might be hard because there's a lot involved, and especially if you feel you've been discriminated against, you're going through it. And, but, sometimes that's why you have an attorney to assist. I always tell clients, I need you to provide the responses. I don't need you to, make sure it looks good or, fancy. Just you put your responses, and then we as the attorneys, we can amend the affidavit to make sure it looks good to the investigator, to make sure it's coherent, and to present the most efficient and appropriate case for you. But the reason I harp on these affidavits is because at some point, should you not continue down with the EEOC and you want to get a final agency decision, which we'll discuss here in a little bit, the decision will be made based on the statements made in your affidavit, the management officials' responses, your rebuttals, and any other supporting documentation you have. So you really want to, you don't want to just write stuff to write stuff, because ultimately that report of investigation, and I shouldn't say it's just going to be used for a final agency decision. That report of investigation is going to be entered into the record should you file an EEOC hearing request. So very important to make sure your affidavits are clear, concise. I mean, it doesn't have to be 100 pages. If it is 100 pages, you just got to make sure that you include pertinent information. Any kind of fluff or anything that distracts from your claims, to me personally, does this just that. It doesn't, it's inconsequential to your claims, and it distracts from it. So these affidavits are very, very, very important. And then, provide, if you have an attorney, provide your, as much information as you can to an attorney. And sometimes the attorney, like if I was working on it, I would say, Mr. and Mrs. Smith, I don't think you should include that. I think it, distracts from your claims, or it might not be consequential. And then you just give the client a choice in that, if the client still wants to keep it in, that's fine. But, you keep it short and simple, to the point. And, sometimes to the point isn't short and simple, but I think you just got to stay on track, make sure you're providing responses to the claims that you allege. You don't want to talk about what you had for lunch that day, or, you won't want to talk about things in your personal life except how the claims have affected you. Short and simple. And then if the attorney feels you need to provide more, he or she's going to ask you to provide more information. And then after all that, the investigator is going to issue a report of investigation. And like I said, this is a compilation of all the documents. And whether you file a hearing request with the EEOC, or you request a final agency decision, that report of investigation is going to be a big piece of quote unquote evidence that's ultimately going to lead to a decision, whether from an agency official or from the EEOC. And then lastly, the agency does have 180 days from the date you file your complaint to issue it. The investigation can be extended up to 90 days. So sometimes if the 180-day period is up, the agency hasn't finished their investigation, they may send you an agreement to extend the investigation by 90 days. You're under no obligation to accept that extension, but something to consider. Because sometimes, you're at the end of the investigation and the agency just needs to finish it up, and you want a full and complete record. But by no means do you have to agree to that extension. And certainly if the agency doesn't issue a report within 180 days, you do have options such as filing a motion for sanctions moving forward. Okay, what to do when the report of investigation is issued. We kind of talked about this. And one thing I do want to say is going back to the report of investigation in the 180 days. They have 180 days to investigate your complaint. If you file an amendment to that complaint, okay, say you file today and in 2 months from now you file an amendment, okay, that investigation then moves to 180 days from the amendment, or, not to confuse anybody, or 360 days, whichever is less. So if you amend it a month or two from now, it'll be 180 days from the amendment. If you amend, say, 6 months from now, they're not going to get a whole 180 days. they'll just get up until 360 days. But what happens after the, what happens after the report of investigation is issued? So that at that point, you have the right to choose between an EEOC hearing or a final agency decision, better known as a FAD. And this is, so what was the first, what was the first thing we talked about, or one of the first things? It's 15 days from receipt of the notice of right to file a formal complaint. So that's the big first deadline. Well, taking it back, 45 days from the discriminatory event to file an informal complaint, 15 days from receipt of the notice of right to file a formal EEO complaint, and now the big thing is 30 days from receipt of the ROI. So if you receive an ROI today, you have 30 days to file a request for an EEOC hearing. If you don't, you can also request a FAD during that time, but what will happen is if you don't do anything, because there's a document that the agency will send you, another doc, another form that you need to sign and fill out to include your request. It'll say, I want to withdraw my complaint, which you probably don't want to. It'll say, I want to request a hearing before an EEOC judge, or the third option is, I want to request a FAD. If you can always request the FAD within the 30 days, but statutorily, if you don't do anything, if you never send in anything regarding the complaint, ultimately the agency will issue the FAD. So if you don't elect anything, they will issue the final agency decision. But if you want to file a hearing request before the EEOC, you do want to do that within 30 days of receipt of the report of investigation. Excuse me. So what is involved in an EEOC hearing? That involves litigation similar to the federal court process. Affords an opportunity for discovery. At that point, you'll be dealing with an agency attorney. But the big thing is you will be assigned an administrative judge who's independent. They're not an agency official, and they will ultimately make a decision if you go all the way to a hearing. And then after that, once the judge makes the decision, the agency has 40 days to implement a judge's decision and inform you of any appeal rights. Now, one thing, and I notice a question here, is an assignment of an administrative judge after you request your hearing. This can kind of go on for a long time, especially depending, the EEOC is very backlogged. So when you file the hearing request, within a week or so, you'll probably get an acknowledgement order, basically saying, we acknowledge you filed your complaint of your requesting an EEOC hearing. However, the assignment of the judge, that may take a while. I think it depends on the different field office you have. I know for a fact, like the New York field office is very backed up. Sometimes the Washington, D.C. office, there's offices throughout the country, whether it's Seattle, California, San Francisco, and California. There's Dallas. There's a whole bunch of offices, but it might take some time. But what you need to understand is the biggest thing is once you filed, you're okay. As long as you have something acknowledging that you filed and it was timely, it may take some time before a judge is assigned. And just don't fret, don't lose hope or anything like that. It just may take some time. And I'm trying to think. I know I filed a hearing request, I want to say over the summer at some point, and I'm still waiting for an assignment of a judge. So that just shows you how backed up some of these are, but it doesn't mean your case is getting dismissed. The only thing I would suggest is, because you do have to sign up for an EEOC portal account to file the hearing request, and you should get email notifications every time something is filed, I would continue to follow up, go on your portal account, make sure you haven't missed anything, but it's not rare for that to take some time. Okay, so we kind of we talked about an administrative judge, being assigned to your case. Let's say, okay, ultimately you get an assigned administrative judge, and then they're assigned to your case. One of the first things they'll do is they'll issue an initial conference order. And the initial conference order will set a date for a conference, usually telephonically or virtually. Usually the first couple conferences, they might be through MS Teams or telephonically, but usually you have to call in. The judges don't usually require to use video right away. And once you have that initial conference order, and if you have an attorney, your attorney will reach out and discuss. But one of the things that is usually in every initial conference order is they want you to define the claims. They want you to work with agency counsel and define the claims. And those claims are listed in the ROI. They're listed on your notice of acceptance of your formal EEO complaint. But it's something the judges are going to want to know. Make sure that if I'm going to adjudicate this case, I need to know specifically what the parties are alleging and the reasons why. And then there's also something the judge is always going to ask the parties to reach out to the other side and discuss settlement. And there's no guarantee of settlement. There's no telling that the agency wants to settle with you, but the judge is going to at least ask you to reach out. And then when you go to that initial conference, he or she is going to say, have the parties discussed settlement? Can I be of any assistance? Do we need to schedule some type of mediation? Now, I've settled cases like that, but then, sometimes agency has no interest in settlement, or quite frankly, sometimes people have very unreasonable settlement demands, or at least to the agency they're unreasonable, and the agency doesn't want to engage in any type of settlement discussions. But the big thing about settlement is you can settle at any time. And usually these judges are very helpful in facilitating. Either they'll have their own settlement conference, or they'll refer your case to like a mediator, and so an outside person can kind of work on resolving the matter. So just something to think about once you do file your hearing request and you do receive your initial conference order. That's going to be something that's going to be discussed during the initial conference. Excuse me. Okay. Now, one thing you get with filing the EEOC hearing request is discovery. Remember what I said back with the FAD, the final agency decision. You basically, if you request a FAD, you're just going to get a decision based on the report of investigation. You don't have the opportunity to supplement that. But the discovery process with the EEOC provides you with an opportunity to basically engage in discovery, request additional documentation. Here it says at this stage, the agency will also likely have an attorney. Absolutely. The agency is going to have an attorney. They're going to want to communicate with you. And I think it's important for people to understand that, and I have to remind my clients of this sometimes, is obviously if you go at this by yourself, you can communicate directly with the agency counsel. If you do have an attorney, though, it's very important that you keep all communications between you and your attorney. Let your attorney reach out to the agency. Don't go over the top and try to communicate directly with agency counsel. One, they shouldn't respond to you. And two, that's what you have an attorney for. An attorney is here to guide you through the process, assist you, right? We know more about this information, or at least these processes, than the client. So you want that person, you have to trust in your attorney and trust that whatever you want them to ask the agency counsel will be conveyed through the attorney, not necessarily the client. And that's not a shot at a client. It's just that those are communications that if I'm on the agency side, I'm not going to even respond to that person if they have counsel, or I might reply back and say, you have an attorney, please make sure all communications are done through, Tully Rinckey or whoever your attorney is. So that's something to keep in mind. And quite frankly, if you continue to reach out directly to agency counsel, once again, if you're represented by counsel, I think it's less likely that the agency is going to want to resolve any of your issues or essentially be any type of helpful in your situation. So that's just a tip. We talked about the acknowledgement order after you file your hearing request, and kind of like I said earlier about the acknowledgement order. You might get the acknowledgement order, and it might be some time before you ultimately get a conference, but don't fret, it will be scheduled. But once you do get that initial conference order, or maybe even after the order is issued, you're going to have deadlines for when to file for discovery, when to file responses, maybe even a deadline that the end of the discovery period is. So and those could fluctuate. It's not as set in stone as the 45 days, the 15 days, the 30 days. But those deadlines are important. You have to abide by them because, once again, if you do not file by a certain time, by a certain deadline, you could prejudice your case. Okay, so we kind of touched on this. In the acknowledgement order, the administrative judge may ask for preliminary case information prior to an initial status conference. So the initial status conference is going to be the first kind of appearance, if you will, where it's the judge, the complainant's attorney, and the agency counsel. And we kind of touched on this. The judge is going to want to know what claims that you filed, if to make sure that everybody's on the same page, if there's any new claims. But then at that point, they're also going to set some deadlines. They're going to set the discovery deadline, and they're going to set summary judgment deadlines. And so essentially what that is they're going to say discovery needs to be completed by a certain date. And usually they set that out for 60, 90 days, and you can always request extensions of that time. But with the deadlines, the discovery, they'll have a deadline in which you need to file your discovery request, and then also file your responses to the agency's discovery request, because the agency is likely going to file them as well. I guess I should address, what is discovery? Discovery comes in, it's essentially getting information and documentation from the agency, and it comes in multiple forms. One is interrogatory, which are written questions. So essentially, you'll prepare questions for the agency to respond to, and they need to provide sufficient answers. Next is a request for documents. So you will ask the agency to produce emails, documents, correspondence, letters, whatever, reports, whatever it may be that you feel is pertinent to your claims. Now, people get in trouble sometimes where they request everything under the sun, and I don't think that's very efficient, because you know, the way to streamline this process, and quite frankly, the way to make the agency take you seriously, is if you're just not asking for everything. I mean, you want to ask for the most pertinent stuff, and if that is asking for everything, okay, but you want to ask for specific documents related to your claims. Are these emails between your supervisor? Is it a memo that your supervisor wrote? Is it a performance evaluation that you're challenging? So those type of things. You know, don't ask for a report that has nothing to do with your claims, because at that point, the agency might not take your case as serious as they should. And then the last thing is requests for admissions, which are, or RFAs, which are essentially statements that you make a statement and that the agency has to admit or deny to. An easy example would be, you know, today is March 19, 2025, admit or deny. And the individual, you know, the agency attorney or whoever's responding to the request for admissions will say admit. Something, you know, an easy example that, you know, admit that, you know, Tom Smith is a male, admit or deny, and then the agency has to admit or deny that. Now, sometimes you try to trick agency counsel, you know, admit that an official was aware of something, or you want to tailor those requests to admissions, once again, to your claims, because you never know. They might admit to something in there that is beneficial to your case. You know, admit that the agency management official was aware that Mr. Smith had a disability, and then they admit it, but then in a affidavit, the management official said, I didn't know Mr. Smith having a disability. And that's where you can kind of catch the agency. It's not a necessarily smoking gun that's going to win your case, but it goes to credibility. So when that person testifies at a hearing, you can cross-examine them on the fact that, well, you said Mr. Smith didn't have a disability in your affidavit, but you admitted that you knew he had a disability in your request for admissions. So you can kind of attack an individual's credibility when they have inconsistent answers. Another part of discovery is depositions. Depositions are essentially testimony on the record. There's no judge involved. It's just you, the attorney, and agency counsel. And it can go both ways. You, as the complainant, can be deposed, and you can also depose management officials. And once again, the benefit of these is to get testimony, sworn testimony on the record, because we already talked about they're going to provide an affidavit. Then if they're deposed, and they're going to now put additional information on the record. And if they contradict their testimony, that goes to their credibility. Or maybe they just make an admission on the record that is beneficial to your case, and then you want to go, and then we can go to the agency counsel and say, hey, this management official's deposition wasn't very good. Maybe you want to consider settling this matter, because if we got to go to a hearing, you're not going to want to put that person on the stand. Another part of that, though, as a complainant, you need to understand is that the agency will want to depose you as the complainant. And that's where you need to be, cognizant of the answers you provide. You want to stay consistent, because no different than, when we talked about management officials attacking their credibility. A smart agency attorney is going to attack your credibility if you state different responses from the time you did your affidavit to maybe when you provided discovery responses, and then also when you're deposed. So some things to think about with discovery. And then after discovery, it's very likely that the agency is going to file what's known as a motion for summary judgment. And a motion for summary judgment essentially states that you could take everything that Mr. or Mrs. Smith said was true regarding their complaints, but the agency had legitimate non-discriminatory reasons for the action they took, and as such, this case should essentially be dismissed. So here's an example. You say, I was up for a position. I interviewed. There are 5 other candidates. I was the most qualified candidate, but I was not selected because of my race. And so the agency, in a motion for summary judgment, obviously they're going to deny that you were not selected because of your race, and then they're going to list what they say are their legitimate non-discriminatory reasons, meaning you weren't the best qualified candidate, you didn't have the most experience, you interviewed poorly, things of that nature, non-discriminatory reasons. And then it's incumbent upon you to then file a response basically stating that those reasons are pretextual, that it was because of your race, and I'm just using race as an example, could be your gender, disability status, things of that nature. So the motion for summary judgment is very big because it's a hurdle that you need to clear, because the agency is very likely 99% of the time going to file a motion for summary judgment, and you need to clear that hurdle for your case to continue. And the thing about that is, even if you do succeed with the motion, meaning the agency files, you oppose it, and the judge sides with you, now you're going to a hearing. It doesn't mean your case is over. It doesn't mean you won. That means now you're going to a hearing. So I saw a question that says, how long do they have to rule after my opposition and the rebuttal? Once again, as long as you, usually when in pretty much every kind of EEOC case, the day discovery ends, and you got to check your orders, you have 15 days to file a motion for summary judgment. After that, once the agency files, you have 15 days to file a response. I've seen it vary, sometimes 21 days, things of that nature. It's important to check your initial conference orders, but for the most part, those deadlines are set in the order. However, once you file your opposition, you might be waiting a long time to receive a decision. I just got a decision recently, and I'm not saying it's going to take this long, but it was, I want to say, 23 months, almost 2 years after we filed our motions that we received a response. Sometimes that's the extreme, though. That's certainly the extreme. You might get a response within a month or two, but if it does continue to move along, I would not, it's not prejudicial to your case. It just may take some time. Some judges are quicker than others. You might get one next week, or you might get one a month from now, but I've seen it go even past a year, and sometimes clients get frustrated with that, and I understand, but that's based on a backlog. And I go back to, when you encourage you to sign up for an EEOC portal account, so you're receiving email updates every time something's filed. And you can also go onto the portal to get updates whenever you want. Okay, so say you beat summary judgment and you go to a hearing. Basically, if you go to a hearing which involves witnesses, exhibits, things of that nature, obviously at that point, you're going to really want an attorney because that judge is going to hold you to the same standard as he or she does the agency attorneys. But say you're successful. If you are successful, the judge will issue an order with the relief you're requesting or you requested. Maybe it involves damages, maybe it involves rehiring to a certain position, whatever it may be, and then the agency has to implement that decision. So obviously that's the good thing. The bad side, if an administrative judge issues a decision that is not in your favor, whether they grant the agency's motion for summary judgment, or even if you beat summary judgment and you go to a hearing and you lose, you do have appellate rights. So once you receive a decision, you have 30 days from the date of that decision to file an appeal with the EEO's Office of Federal Operations, or OFO. Now, the 30 days is important as it's a form you fill out, and it's essentially, I intend to appeal. And then once you file that, you then have 30 days to file a brief in support of your appeal, okay? So, big thing, 30 days from the decision to file the appeal, and then once you file the appeal, 30 days to file the brief in support with all your arguments as to why you should have been the prevailing party at the hearing, or all the reasons that you should not have been, or the agency should not have been granted summary judgment. And then the OFO will review everything, and OFO will eventually issue a decision. Once again, this takes some time. And I don't want to be a broken record, but I just want everybody to understand it's not anything that you as the complainant do. It's an administrative backlog with the EEOC. As an attorney, sometimes it's frustrating, but it's just something we have to deal with. So if you do file an OFO appeal, I got a couple out there that I know I've been waiting for over a year or two for a decision. So just something you have to consider when filing. Okay, so when can you file a lawsuit against your agency? Now, a lawsuit in a sense of is filing in federal district court. You file with the EEOC, you file a formal complaint with the agency. I don't necessarily consider those lawsuits. It's a legal matter. But when you say a lawsuit, you can file in federal district court. You can file after 180 days from the time you file the formal complaint if no FAT is issued and no OFO appeal has been filed. If within 90 days after you receive the agency's final agency decision and no OFO appeal is filed. So going to federal district court is that you have to, if you're with OFO, if you're with the Office of Federal Operations, you can't go to federal court right away. You have to let that process play out. If you file an OFO appeal and you haven't been issued a decision, you can file a lawsuit in federal district court. Or if you do receive an OFO decision, you can file in federal district court. One of the other questions we said you're referring to an AJ. Does this proceed also include filing with the MSPB? So administrative judges, yes, applies to both MSPB and EEOC. But I think it's important to note that those are two separate tribunals. They're administrative tribunals. EEOC primarily deals with complaints of discrimination, kind of like we're talking about. MSPB deals more with personnel actions against an individual. You're removed from, you get a proposed removal and you're ultimately removed. If you have a suspension of 15 days or more, whistleblower claims, those are cases that are adjudicated by the MSPB. You can have some discrimination aspects to an MSPB matter, although they're very limited and it gets complicated. But for the most part, MSPB is a separate tribunal, involves personnel actions. Like I said, whether you're removed, suspended, there's disability retirement is handled by MSPB, but think about the EEOC mostly for your discrimination aspects. Okay, another question. If an administrative judge grants the agency's motion for summary judgment, I file an appeal with OFO. How long does it take to OFO rule on the appeal? Also, if OFO does order and remand it back, does this make the agency more likely to settle? So two-part questions. One, like I said, it could take a while. If you, as long as you file your brief in support of the appeal, or you don't even have to file a brief, as long as you appeal it, you will have time to, you will ultimately get a decision from OFO. If they do reverse and remand, will it make the agency more likely to settle? I mean, I can't say for sure, but I would say yes, because previously, at least they got a decision in their favor. But now, if it's remanded back to a hearing, then maybe they will come to the table now and realize, okay, hey, we might have to go to a hearing on this and give you reach out to you for settlement purposes. Why should you engage an attorney in their process? And I think, one of the things that I've been talking about for 47 minutes here, and that, I'm hitting home on, is timeliness issues. You really, this is something that, not saying you as an individual can't keep track of these, but these are something as attorneys, we're familiar with the process. We track them all the time. One of the things that I, as an attorney, never want to do is miss a deadline, because you could have the best arguments in the world, and if you miss a deadline to file something, you've extremely prejudiced your client's case. So it's very important to meet deadlines, and that's what an attorney would help you with. Sometimes individuals aren't able to articulate their claims or their reasons as much. And essentially, as an attorney, you have an attorney as your mouthpiece. Your attorney can interpret things for you. Your attorney can provide guidance. And quite frankly, an attorney can help you deal with agency counsel. Some of these agency counsel, some of them are nice, some of them are not so nice. And, as a person who deals with them on a daily basis, I know when to press them. I know when to kind of fall back and maybe work with them a little bit. You just kind of gotta feel them out. And a lot of times, that just having an attorney gives you the peace of mind that you don't have to, not saying you don't have to worry, because it's your case and you want the most favorable outcome. But the attorney is going to do most of the work for you. The attorney is going to do the negotiating. You, as the client, you have every right to engage in that stuff. You have every right to let your opinion know. But the attorney is going to provide you that guidance. So, I always use the example. If my knee hurts, okay, I'm going to go to the doctor. If I got a sore throat, I'm going to go to a doctor eventually, if it gets severe. I'm not going to try to treat myself. I'm not going to try to diagnose myself, because I don't know the first thing about medicine. Okay, I want to put an addition on my house. I don't know. I'm awful as a contractor. I'm going to hire a contractor to put that addition on my house, because I know they know the process. I know that's their area of expertise. Same thing applies to an attorney that you might not understand, or you want to make sure you have peace of mind knowing that someone can assist you in the case. That's why you should get an attorney. Okay, so what can Tully Rinckey help you with, our firm? We can help you basically, you read everything on this slide, but essentially we can help you start to finish. We can help you from the time you file an informal EEO complaint all the way to, an appeal of a judge's decision and everything in between. And we can also essentially, with the EEO, you can enter in at any time. Say you went through the formal process by yourself, or the informal process, and even the formal process. And then you said you filed a hearing request. And then after the initial conference, you're thinking to yourself, hey, I might need to get an attorney involved. That, you can hire us then. I think it's important that, maybe a client try to, hire an attorney as soon as possible, so that attorney can be with that client, the pendency of their matter. But we can provide services, and we can, notice our representation at any time. I've even, noticed my representation on a case that was scheduled for a hearing, I want to say a month away. Now, that's going to get very costly to you, because the attorney is going to have to catch up on everything, understand your claim. But even if you're on the eve of hearing, and I'm not saying the day before, but, at least a couple weeks before, or more than a month, as long as you're willing to pay, we can get involved in that type of matter. Okay, what do clients need to bring during their consultation? So, big thing is you gotta be able to articulate the discriminatory acts: the what, the when, the where, the who, and the how. And also dates, I think, are like a timeline is important, because like I said, if you come to me today and you start talking about something that happened in September 2024, I'm going to say, I'm sorry to hear that, but that's very unlikely to be a valid claim because it's untimely, not 45 days from the date of the event. So it's also important to get your responsible management officials. You know, Sally Jones, Tom Smith, that's my first line. That's my second line. Those individuals, because we do have to run conflict checks to make sure we haven't represented any of those individuals. And also any witnesses. Hey, my coworker Daniel, he witnessed this harassment. He witnessed this discrimination. So those are all things that you should bring to your consultation and articulate to your attorney or the individual you're talking to. Okay. Couple things to remember. Discrimination should never be accepted or tolerated. You might want to consult with an attorney before any claim. You want a complete timeline of your events. Remember your deadlines and be prepared for a long battle. And I think if I can't emphasize enough, those last two ones is your deadlines, because I'll say it again, you could have the best claims in the world. You could have the best complaints. If you miss any of those deadlines, there doesn't need to be some special reason to dismiss. You know, if a judge finds that your claim isn't discrimination for, you know, reasons X, Y, and Z, you know, you can always challenge that. But if you don't file if you do not file something on time, whatever deadline that may be, you are severely prejudicing your case. Not even severely, you're killing your case, because your case is going to be over at that point. And be prepared for the long battle. Whether it's an assignment of a judge, whether if it's a contact from an investigator, as long as you're doing your outreach and you're doing your due diligence and making sure you've done everything you can, it can take a long time. There is a question, is there a reason why investigator will not interview all of the witnesses you name? That's really up to the investigator. The one thing I would say to that question is, though, just because the investigator doesn't interview them, should you go to a hearing and file an EEOC hearing request, you can always name those individuals as a witness at the hearing, because if you go to a hearing, prior to that, you're going to have to submit something called pre-hearing submissions, and the judges usually want you to name that witness and provide like a proffer of their testimony, meaning a brief summary. You know, person X is, you know, going to testify to the harassment, the discrimination the complainant faced, specifically the event on March 19, 2025, where the individual used discriminatory remarks towards the complainant. So you can always name, if you feel that a witness was not interviewed, you could do one. You could have that witness provide an affidavit of your own. You know, have them type up an affidavit, get it signed in front of a notary, and give it to the investigator and say, put this in the report of investigation. If it's in front of a notary, it's under oath in a sense. And then also you can have that person testify at a hearing, or list them as a witness, and then he or she could testify at your hearing. I know we got a couple minutes left here. I have some submitted questions. So let me take a look. I highlighted some. The formal EEO process during the current administration. That's a good question, especially what's going on these days in the federal government. I wish I had a better answer for everybody, but you just don't know. You know, you can still file. The one thing I would say is, regardless what's going on with the current administration in the state of our federal government, make sure you file your complaints and make sure you have documentation showing you did, because you never want them to say, oh, we didn't read it. We didn't receive it. Here's a read receipt. Here's a certified mail receipt, things of that nature. So with the current administration, it might take some time, or, you know, but I would consider making sure, if you do want to file a complaint, that you really go forward and you document everything. Identifying and dealing with management retaliation after a complaint has been filed. Okay, that's a great question. So we talked about protected basis, your race, your religion, your gender, your sexual preference, disability. One protected basis is reprisal or retaliation, meaning if you file a complaint today and then down the road you feel your manager is retaliating against you because of that complaint, you can amend your EEO complaint to include retaliation as a protected basis, just like race, religion, gender, things of that nature. So remember, though, just like with the other basis, you have to connect that. You can't just say it's retaliation because I filed. You have to link the two. I hope the management official's not that ignorant to say I'm doing this because you filed a complaint, but you got to remember to be able to tie that to your filing of the complaint. There's an argument called temporal proximity, meaning, you filed something today and then there's an adverse action against you 3 days after that. That's pretty close in time for that to be considered retaliation, or retaliation for you filing a formal complaint. And even the case law says months could still be a close enough temporal proximity to constitute retaliation. And the last question I'll answer here is the pros and cons of selecting a hearing or a FAD. The one thing I'll say to that is, excuse me, is that with a FAD, you're essentially asking an agency official to determine if another agency official discriminated against you. And that is, I don't really have much faith in that. Now, the person who makes a decision on the FAD has nothing to do with your complaint. They didn't investigate it. They're not a management official in your complaint, but you're asking another agency official to say another official discriminated. In a sense, you're asking another VA employee, you're asking another Department of the Army employee to determine if another individual discriminated against you. And I don't necessarily have much faith in that. And that's why I think going to a judge is easier, because that is an independent third party. They have no skin in the game, if you will. And, that's, and also you want the attorney to guide you through that process. But sometimes it comes down to cost. And you say, listen, I don't have the money to hire an attorney, and I don't have the just patience or even time to continue by myself. At least you'll get a decision with the FAD. And one more final, well, two things. I do see a question. Can you file a complaint regarding things from prior you did not find out until after? Yes. So something could have happened a year ago, but as long as you can verify and prove that you did not know about it until, say, today, then it's 45 days from the date you knew or should have known, okay? So just make sure those claims are kind of tricky, but if you can prove that I had no notification of something, something happened 6 months ago, I had no notification until just today, then yes, you can include that as part of your complaint. And the last thing I'll say before I let everybody go, just a piece of advice, discrimination, it's not cool. There's no place for it in the workplace or in the world for that matter. But one thing I would implore to people to understand is there's a difference between your supervisor discriminating against you and them just being a jerk or a bad person. So, if your boss is being a jerk, if they're not a good person, that doesn't necessarily mean you've been discriminated against. So if you are going to file, if you are experiencing discrimination and you are going to file some complaint, you got to make sure you can link that to your protected basis, your race, your religion, your gender, your disability, your sexual preference. Because otherwise, it's just your boss being a jerk, and as bad as that is, it's not discriminatory. Okay, we're right at 1 o'clock. I've been talking for about an hour now. You have our information here. I encourage anybody that has any pending complaints or is potentially wants to move forward with a complaint, you reach out to the address or the email, the phone number or the email address on the slide here, and you reach out to schedule a consultation with one of our attorneys, and hopefully we can help you along. With that being said, I thank everyone for their time, and I hope everybody has a great rest of the day. Thank you all.